Good morning, everyone. Today, our team will present one of the most influential cases in modern Charterparty law, the Achilleas, a landmark decision on late redelivery and the scope of damage in a chapter. Let's begin. Here are the members of our group. The vessel involved is the Achilleas, a single-decker bulk carrier built in 1994. On 22nd January 2003, the Achilleas was fitted on a time charter for 5 to 7 months at a higher rate of 30,500 USD by Chatfield Shipping. During the period of the time charter, the owner hired the vessel on a daily basis, while the charterer paid the operating expenses. The owner retained title to the vessel and overall control over its commercial employment. The Charterparty may include a dental for extension or higher adjustment in line with market conditions. In case of late delivery, the charterer is liable only for the difference between the contractual hire and the prevailing market rate during the extended period, and is not liable for the owner's lost profit under any subsequent feature. For incident summary, until September 2003, the party fixed the vessel for a further 5 to 7 months at a daily rate of 16,750 USD. The last day for redelivery was 2nd May 2004. By April 2004, market rate had more than double compared with the previous September. On 20 April 2004, the charterer gave notice of redelivery between 30 April and 2nd May 2004. On the following day, the owner fixed the vessel for a new 4 to 6 month hire to another charterer, following on from the current charter at a daily rate of 39,500 USD. The last day for delivery to the new charterer, after which they was tied to cancel, was May 2004. With less than a fortnight of the charter to run, the charterer fixed the vessel under a subcharter to carry coal from Qingdao in China and Prague, the Yellow Sea to Detroit at two Japanese ports, Tobata and Oita, but was unfortunately delayed there and not delivered to the owner until 11 May. By 5 May, it had become clear to everyone that the vessel would not be available to the new charterer before the cancelling day of 8 May. By that time, they had fallen again. In return for an extension of the cancellation day to 11 May, the owner agreed to reduce the rate of hire for the new fixture to 31,500 USD a day. Let me begin with a brief overview of the general background of this dispute. The charterer redelivered the vessel 9 days late. The ship owner had already fixed a follow-on fixture with cargo at 39,500 USD per day. Due to the late redelivery, the owner had to renegotiate, accepting a reduced rate of 31,500 USD per day for the entire 192-day feature. Finally, what damage is the charterer liable for?
We would like to welcome our teacher and all classmates to watch the course session.
Alright. The court is now in session. The matter before the court is the owner of the Achilleas versus Redelivery Shipping.
This dispute concerns the measure of damage for late redelivery under a time charter. The owner claimed over 1.36 million USD based on the loss suffered in a follow-on fixture. The charterer argued damages are limited to 58,301 USD. The market or higher differential over the 9 days of late delivery. Counsel for the owner, you may begin.
My lord, this is a case about contractual certainty and the natural consequences of break. The charterer redelivered the vessel Achilleas 9 days late, fully aware that the owner had arrayed or was likely to array a follow-on charter. Because of the delay, the owner missed the cancelling day for the follow-on fixture and was forced to renegotiate to higher freight from 39,500 USD down to 31,500 USD per day for a period of 192 days, resulting in a loss of over 1.36 million USD. The Court of Appeal unanimously held, firstly, the loss was not too remote. The second is the charterer knew and ought reasonably to have known that missing the cancelling day was not unlikely if they deliver late. Finally, the loss therefore fell within the first leg of Harley versus Passendale. The majority arbitrators expressly felt it was not unlikely result that late redelivery would cause owners to low or renegotiate the net fixture. In volatile market, trading schedule was tight. Charterers were aware of this industry reality. Therefore, the loss arose naturally in the usual course of things. Finally, this is the core of our case. The charterer caused the owner a loss that was natural, foreseeable, and not unlikely. This places the loss within the classic measure of contract damages. We will show that the owner are legally entitled to the full 1.36 million USD.
My lord, while the owner's narrative sounds compelling, it distorts the law and disregards market reality. The question is not whether the loss was foreseeable in some broad sense. The real question, confirmed by the House of Lords, is did the charterers assume responsibility for this type of loss? The answer, based on every authoritative finding, is no. Lord Hoffman explains that even if a loss is foreseeable, a party is only liable if they can reasonably be taken to have assumed responsibility for that type of loss. The loss here was unquantifiable and not a type of loss that charterers commonly bear. The majority of arbitrators acknowledge that the general understanding of the shipping market is that damages for late redelivery are always measured by the higher or market differential for the overall period. The dissenting arbitrators stress that no case, no practice, no textbook support owners' claim. The assumption of responsibility text require proof that charterers agreed expressly or implicitly to cover such extraordinary losses. Yet, not charterer in the industry prices the risk of losing a future fixture. No owner expects that risk to be covered unless expressly agreed. There is no precedent supporting owners' approach. Thus, as the House of Lords ultimately held, the loss is too remote, not because it is unforeseeable, but because the charterers never assumed responsibility for it.
Have been several for 25 years.
Yes,
Is it common for owner to negotiate follow-on charter before redelivery?
it's a standard practice.
Would charterer typically know this?
Absolutely, it's a basic commercial reality.
Would you say that the vessel is redelivered late? The rate of the misses, the cancelling day of a follow-on fixture is not unlikely.
correct is based in volatile markets.
Mr. Wu, when charterers ask their lawyers or be a nightclub what damage they face following redelivery, what is universal answers?
That they are liable for the difference between the charter rate and the market rate for the day hour.
So the industry standard and the assumption of both parties is not that charterers pair loses from future fixtures.
That is correct.
Thank you.
You said as a member of the arbitral tribunal.
I did.
And you were part of the majority.
Yes.
The majority concluded that the loss fell within the first limb of Harley versus Passendale because it was not likely to result from late redelivery, correct?
That was our conclusion.
You also acknowledge, did you not, that the market understanding with the charterer's liability is restricted to the market or high differential?
We acknowledge that understanding, yes.
And the dissenting arbitrator stressed that departing from this understanding would cause serious commercial uncertainty, correct?
That is what he wrote.
And yet you disregarded this established market practice?
We apply the legal test of remoteness as we understood it.
But the House of Lords later held that crucial question is assumption of responsibility, not mere foreseeability. Would you agree that your majority of words did not address this distinction?
We did not frame the issue in those terms.
Thank you.
My Lord, the fundamental test as articulated in Harley vs. Passendale and reinforced in the Heron 2 is that damages are recoverable if they arise naturally or they were in the reasonable contemplation of the parties. I would like to emphasize that review the follow-on feature is stated or were highly likely. They knew that late redelivery could disrupt that feature. They knew volatile market modified the rate. The majority arbitrators specifically held that the loss were not likely to result. Furthermore, the Court of Appeal held the loss would not to remove. The charterer must be taken to have foreseen the possibility of renegotiation. The owner loss were exactly the type contemplated in the ordinary cost of commercial shipping. Damages of 1.36 million USD are justified.
My Lord, foreseeability is only half the equation. The modern law clarified unequivocally by the House of Lords requires a demonstration that the breaching party assumed responsibility for the type of loss. Lord Kaufman explains foreseeability alone does not impose liability. Commercial parties must be shown to have allocated the risk. If a loss is too unusual, too unpredictable, or too unquantifiable, the law will not treat the risk as assumed. Here, the follow-on fixtures, duration, rate, and sensitivity to dates were unknown at the time of contracting. The potential loss was limitless, depending entirely on future market swings. Charterers cannot control or price this risk. The shipping market universally assumes that damages are limited to the overall period. This is the key principle. A party does not assume responsibility for losses it cannot access, quantify, or control. Thus, the owner's claim collapses under the exemption of responsibility tax.
The loss were foreseeable, natural, and not unlikely. The taxer must face the consequences of their breach. This is judgment for 1.36 million USD.
Foreseeability is not the standard. Assumption of responsibility is. The shipping market has never treated follow-on fixture losses as the charterer's risk. The House of Lords made clear that such losses are legally too remote. We ask the court to award $158,301.
After reviewing an arbitral award, commercial court judgment, cost of appeal reasoning, and the authoritative analysis. 1. The loss, although foreseeable in a process, was not a type of loss that charter assumed responsibility for. 2. Market practice demonstrates that liability is limited to higher or market difference for the overall period. 3. The loss of a follow-on fixture is outside the ordinary cost of Charterparty damage. 4. Imposing such liability would create commercial uncertainty and constraints in industry allocation of risk. Therefore, the recoverable damages are limited to $58,301 USD. Judgment for the charterer.
All right.
Now let us look at the damaging claim by the ship owner. There are two separate heads of loss that the owner relates on. First, we have the loss of use, which is the conventional measure applied when a vessel is redelivered late. This measure compensates the owner only for the overrun periods. In this case, the 9 days of late delivery. The calculation is straightforward. We take the market rate and subtract the charter rate, then multiply by the 9 days. Based on the figure from the arbitration, the market rate was about 39,500 USD per day. The charter rate was 16,750 USD per day, which gives a difference of roughly 22,750 USD per day. When we apply this difference to the 9-day overrun, the conventional damages amount to approximately 158,301 USD. But the owner argued that this conventional measure is not enough. They claim a second, much larger category of damages, the loss of profit. On the follow-on chapter, according to the ship owner, the delivery caused two major consequences. First, they lost the original cargo feature at 39,500 USD per day. And second, they were forced to accept a significantly reduced rate of 31,500 USD per day for the entire 192-day period. This reduction represents a daily loss of roughly 8,000 USD over 192 days. That adds to around 1.52 million USD. Based on this, the owner claimed damages of approximately 1.36 to 1.52 million USD, far exceeding the conventional 158,000 USD calculation. Now, let's move on to the damaged or more accurately the extent of liability of the chatterer. The key point here is that the chatterer themselves did not suffer any loss. The issue is simply how much they must compensate the shipowner at the initial stage, including the arbitration, the High Court, and the Court of Appeal. The chatterer was held liable for the entire loss on the following feature. That means the liability of approximately 1.36 million USD. The court accepted the Honor's argument that the late redelivery directly caused the loss of the cargo contract and the reduced rate for the 192-day feature. However, the final decision by the House of Lords took a very different view. The House of Lords ruled that the chatterer is liable only for the conventional measure, about 158,301 USD, and not for the multi-million USD follow-on loss. Why? First, the follow-on feature loss was considered too remote. Second, the chatterer did not assume responsibility for fluctuation in the charter market. And third, at the time the contract was formed, the party could not reasonably have contemplated that a 9-day delay would expose the chatterer to such a massive loss. In conclusion, on 9 July 2008, the House of Lords handed down a judgment that unanimously upheld an appeal of chatterer. The compensation for late redelivery of 9-day desert, 158,301 USD, not 1.36 million USD, overturning a decision of the Court of Appeal, the High Court, and the majority of arbitration. Their lordship ruled the chatterer are not responsible for the owner loss of profit on their next feature due to late redelivery of the vessel under a TAP Charterparty. 9 days of overrun lower higher rate of the following feature, 8,000 USD per day. But such a volatile market situation could not have been reasonably foreseeable for both the chatterer and the owner when they entered into the contract. Therefore, the breach of the contract is assumed too remote to be given right to claim for damages suffered by the owner.